or LAM, and is a human rights advocate with 30 years of experience advocating for changes in policy and legislation around disability rights in Lesotho. Advocacy is okay, sorry. Advocacy designs and leads LNFOD disability specific and inclusive projects and trains and builds the capacity of disabilities specific NGOs and INGOs and liaises with national and international organizations to advance cooperation and effective implementation of the rights of persons with disabilities in Lesotho. In this role, he also worked on the adoption on the convention on the rights of persons with disabilities, CRPD, and provided technical expertise on the drafting of the disability rights legislation, transforming the CRPD into an act of Parliament in Lesotho in order to enforce the rights of persons with disabilities at the domestic level. He also mobilizes resources for the effective coordination and implementation of the rights of persons with disabilities from donor agencies, disabilities from donor agencies. Yeah. So with this, let me invite Advocate Sikozi to do his presentation. You have maximum of 30 minutes. My apologies because we ran out of time. We humbly request you to do the presentation within 30 minutes. Thank you so much.
Thank you very much. Now we start with the presentation, which is on the new developments happening for the inclusion of people with disabilities in this world. So my presentation is structured as follows. So first of all, I will introduce my organization and the work that we are doing, followed by the recent developments happening in terms of access to justice for persons with disabilities in Lesotho, including the accommodations, court rules which have just been adopted, and the challenges for the implementation of such court rules. So about NFOD. NFOD is the umbrella organization of persons with disabilities. So that means it's a OPE. We are envisioning a society that is accessible and inclusive of all persons, and that enables persons with disabilities to enjoy their human rights and to realize their potential. So we do this through our mission, which is to advocate, promote, and defend the human rights of people with disabilities and their families through training, through provision of training, emotional support, and by also representing the interest to government, private sector, development partners, and the wider community. So through this, so we are achieving our mission through the implementation of different projects. So today I'll just be focusing on access to justice, but we do have a number of projects in different areas to ensure that the rights of people are being protected in the soul. So in 2021, the Parliament passed an act of Parliament called Persons with Disabilities Act, which establishes the independent council on the rights of persons with disabilities, recognizes the rights of persons with disabilities, and also ensure equal treatment or equal opportunities for persons with disabilities, and we found. So Section 32 of this Act is on access to justice for persons with disabilities. So it requires the Chief Justice to ensure access to justice for persons with disabilities by, among others, making the court rules, which will ensure that persons with disabilities also access justice on an equal basis with others. It also requires the government to ensure that when persons with disabilities are being arrested, they are being kept in accessible correctional facilities that can be able to accommodate persons with disabilities. It further states that persons with disabilities are competent and compatible to give evidence in court, either as accused persons, as witnesses, or as litigants. It also states that in doing so, the court will provide assistance in every manner possible to enable persons with disabilities to participate in the legal proceedings, so that they are also able to access justice or they participate in collective just like any other person. So now this is where the issue of accommodations come in. So, let's get into this section. The Chief Justice made and published the court rules administering the cases involving persons with disabilities in 2023. I think it was in May when these court rules were published. So the court rules were developed immediately after the enactment of the law to ensure that persons with disabilities are also able to participate equally in the court proceedings. And so now they are referred to as the disability FPT procedure rules, meaning that they are regulating procedural accommodations that are provided in courts. And as Dr. Diana said in the morning, I think we might all remember that these ones are not provided on the basis of proportionality, but they must be provided regardless of the cost which may be incurred in order to ensure that they are being applied in court. So now that is the purpose. So now these objectives, I think they are about 20 in number. I mean the court rules, they're about 20 in number, and they consist of the objectives. The first objective is to ensure effective access to judicial services for persons with disabilities, so that they may be able to participate in court just like any other person. So the second one is to ensure that the rights of persons with disabilities are recognized and respected. So the last objective is to guide the judicial officers, legal practitioners, and other staff on how to accommodate persons with disabilities in court proceedings. And so now let's go to the application of these rules. So it is said that this application, these rules will be applied during pre-trial, within the trial, and post-trial in order to ensure access to justice for persons with disabilities. And they are applied by the High Court and all the subordinate courts. So that means they could be applied at the High Court and all the lower courts to ensure that the rights of persons with disabilities are protected or they are being provided with the conditions that they need when participating in the legal proceedings and in court proceedings. So now we will go to the interpretation. So the court rules have outlined a number of specific concepts that have been defined. So I did not take all of them. I think I have only picked out one, which is the intermediary. Because I had yesterday when my colleagues were discussing about, I think it was the last panel, that was talking about the role of the intermediaries in the provision of justice. And then I think one of the colleagues there said that the role of the intermediary is to facilitate communication between the person with a disability and the court. So in Lesotho, the intermediary, I think, has been defined differently in the sense that it says that it is the person that has been appointed by the court through whom the person with a disability may testify. So I think this provision might have been influenced by the practice of intermediaries in Lesotho, because in Lesotho, the intermediaries, I think, might have started to be present during the enactment of Children's Welfare Act, and they are normally used in the court children. So that is where they have been used quite a lot. And in that case, they have been having so many functions and rules which include testifying on behalf of the children where there is such a need. So meaning that our intermediary as covered by the court rules has followed that route. So it might not be in line with the requirements of intermediaries regarding persons with disabilities. Okay, yes. So now the other provision of these controls talks about the barriers that are facing persons with disabilities, or that are hindering persons with disabilities from participating in the justice system. So these rules actually requires the court to consider all factors that may hinder a person with disability from participating effectively or equally in court proceedings, and the court is mandated to eliminate, mitigate, or minimize such barriers in order to enable the person with a disability to participate in the court proceedings. So this includes making sure that the legal proceedings are not complex and are easy to understand for persons with disabilities. Inappropriate language, it has also been cited as one of the factors that may hinder effective participation for persons with disabilities, and the court is under the obligation to ensure that such language is not used during the proceedings, including the relevant questions or the questions that may carry more than one meaning. Now the court is in charge of making sure that the defense lawyers or any other lawyer participating proceedings, is not bringing all those issues that may end up producing a witness with a disability. So now, when it comes to competence and compatibility, the court rules provide that all persons with disabilities are competent and compatible to testify in court. I think they are trying to enforce that provision under the law, which has also said that persons with disabilities are competent and compatible to testify before the court. So he has also stated the same rule in this section, meaning that no person with disability is supposed to be denied access to justice on the basis of or lack of competency, as we have been discussing or seen in other cases where they denied such a right. But this should also be subject to the provision of accommodations that are needed to ensure that the person is able to participate in the proceedings. So now the court also has the power to assess the accommodation needs of the person with a disability before the proceedings or during the proceedings. The court has that obligation of ensuring that it is able to understand the condition or the barriers that may hinder effective participation of the person with disabilities in court. And this duty has been placed on the presiding officer, and it is said that the presiding officer has that duty of conducting the assessment, so which is the social assessment in this case, not the medical assessment, to make sure that they know how the witness the kind of disability and the barriers that the witness may face when testifying in court. So it is said that this information will now inform the presiding officer to apply or to ensure that the accommodations that are required are being provided for. So it is further said that the court may further hear the evidence from the intermediary to ensure that they understand the communications from a person with disability. So I think in this context, the intermediary is also asked to give evidence on behalf of the person with disability, which is something that I think is not in line with what the role of the intermediaries are. But like I said, this might be the jurisprudence from the children's court, and there's been incorporated here as a way through which sometimes evidence from a person with a disability, maybe communication barriers can be obtained. So it is better said that understood that where a person with a disability has been arrested, it is the obligation of the investigating officer to identify the barriers that might hinder that person from participating in the proceedings. And the investigating officer should bring such a person to the court, and now the court will remand such a person outside the custody. So now we also have the pre-trial visit to the court. So now this is where the rules are now requiring the presiding officer to take the witness with the disability to court, to introduce the witness to the settings of the court, to familiarize such a witness with the settings of the court and to explain the rules and that each player will be during the trial. And the roles of the judicial officers are also to be explained to such a person as a way of accommodating the witness. So we also have a rule on explanation of manner of testifying. So now this is where the court will explain, or the court is under the obligation here to explain to a person or a witness with a disability the manner of testifying. That the person should speak the truth, and where they may not understand the questions, they have to tell the witness that the witness has the right to say he does not remember or he has forgotten. I think this is just a way of accommodating some kinds of disabilities that may require this kind of accommodation to ensure that they are not intimidated while they are testifying, and they know that they should assist the court with the truth, and where they don't understand, they have that right of trying to inform the court, and they will be given a chance to tell the story. So the other rule is about meeting with the judicial officer. So this is where, before the trial, the judicial officer will meet with all the involved parties, including the prosecutor and the defense counsel, to introduce a person with a disability who is a witness, and also to understand the needs of the person who will be involved, or maybe the barrier that such a person will be involved. So it's like the court rules here actually are trying to make sure that the issue of disability comes before or prior to the beginning of the trial. Maybe it's also part of making sure that the assessment is done and the accommodations are done well before the trial. So the other accommodation which is provided here is, the rule also covers accommodation concerning the special measures for preventing exposure of the witness to the accused person. So this happens normally with cases regarding sexual gender-based violence, whereby the court can, through his observation or maybe with the application of the prosecutor, will apply for this accommodation, which will ensure that the accused person is not sitting in the same room with the witness, but making sure that the witness can be heard by the accused and the defense lawyer while testifying. So this is also a way of making sure that the witness is being prevented or is being protected from being exposed to the accused. I think this has also been discussed during the previous discussion here as one of the accommodations that will be provided to the person with a disability. So there is also a provision on explanation of manner of testifying. Okay, I think this one maybe I can skip because I have already talked about it. Okay, so there is also a provision on mode of questioning. So now this is where the court is under the obligation, or maybe when there is a witness with a disability, the court is mandated to make sure that witnesses with disabilities ask questions in a manner that they can understand, and the questions are simplified, and either the defense lawyers are prevented from asking questions in an aggressive manner. We know how lawyers are when they are cross-examining a witness. Such kind of behavior are prevented. The court is taking over there to make sure that such questions are not posed to a witness with a disability. So this also includes the issue of character assassination, whereby we know that lawyers can sometimes try to do that. They are not allowed to do that because that also makes it very difficult for the witness to be comfortable and to be able to give evidence confidently. So even the nuclear questions or general questions or the questions that are getting more than 1 million or ambiguous, the court will have to stop them. Someone who is actually playing those questions in court to make sure that the environment is in such a way that it enables the person with the disability to testify. I will go to the last one, or maybe I think we are about to finish now. So now, with these rules, now the Chief Justice requires the training of all the magistrates, and the prosecutors, and the legal practitioners on disability rights and access to justice, so that they will be able to apply these rules. So that means there should be training that needs to be conducted in order to ensure that we know all these rules and we apply them. So our organization has been supporting the judiciary in some of the activities that we are doing to ensure that trainings on particular are provided so that the judicial officers and everyone that is involved are able to implement and enforce these rules for the sake of witnesses with disabilities. Okay, so now when we come to enforcement of these rules, in Lesotho, I think it was in May or June this year, there was a section on sexual offences cases whereby our organization was invited to support the court in providing accommodations and doing assessments for witnesses with disabilities. And there were about 12 cases that were involving people with disabilities, and all of them were on sexual violence. And the kind of accommodations that were provided by our colleagues who have been trained as intermediaries as well include the accommodations on language, and also on simplifying questions, and also we raised awareness about the presence or the existence of these rules, because it came to our notice during that session that some of the judicial officers were not aware of these rules, and we had to sit down with them to try to explain the importance of applying these rules, especially in cases that are involving persons with disabilities. So that means we still have that gap of knowledge of these rules across the ecosystem of the judiciary. Not everybody is aware of them. And we also know the issues of attitude that we have spent, or actually we are the products of the legal, of the colonial legacy, whereby we have been trained as lawyers that persons with intellectual disabilities and those with disabilities do not have legal capacity, and I think it's taking us time now to come into good terms with that, it's no longer the case, that we need to apply these rules to ensure that we are able to to provide equal access to justice for persons with disabilities in our justice system. So the other problem is that disability, the understanding of disability is still a problem, especially understanding disability in a social or human rights-based manner across the judiciary. So many people still believe that disability can only be ascertained by or through medical assessment. But we have been working with other magistrates in the districts, and I think we have some of the best practices from them, whereby in cases where disability had to be identified before, we have been able to support for with the social assessment, whereby we either call people that are living with such a person in the community, or a teacher or such a child to come and testify before the court of the disability of such a person. And it has been working in other districts. So the way we see it is that I think it still depends on the attitude of the magistrate or the prosecutor, or even the police that are investigating such cases. So if they feel that it will take their time, then they abandon it. But sometimes if they want to work on it, then they are able to seek support from us. And we are always available to support the court. So now this is one of the challenges that we are facing. I think the last challenge, the last challenge I think is with regard to the ecosystems of the laws. I think our country is a state, not I think, but our state is a party to the UN Convention on the Rights of Persons with Disabilities, and it has also signed the African Disability Protocol. So we are now pushing for the ratification of that. But most of the laws are still inconsistent with the convention, because they require other things, especially the medical assessment for where maybe disability is in question. So that also poses a problem. I think with this work, I would like to stop here and also say that these court rules are not perfect, but they are a step in the right direction. Thank you.
Thank you very much for that really interesting presentation. I just want to find out, you mentioned that the court rules are applicable to the High Court and subordinate courts. Are the higher courts not applying these rules? And that's the first. And secondly, I also wanted to know the extent to which persons with disabilities and their organizations were involved in the formulation of these rules. Thank you.
Okay, thank you for that question. Yes, the rules still clearly stipulate the course that would be applying these rules, and it looks like the higher courts are not needed. So in terms of the participation of persons with disabilities during the design of these rules, yes, what I know is that we have been consulted, but I think most of the submissions of persons with disabilities have not been included in the final version of these rules. That's why I think we still have some challenges here and there in making sure that they fully address the issues of persons with disabilities. I know that during the development of this, we were with so many organizations, including ICJ, and I think, yes, the Guyana was also a part of these consultations. Yeah, but it looks like they have most of the submissions have not been finally incorporated.
Yes, Mr. Kasi, thank you. Actually, you have answered my question because I wanted to just make a follow-up. Remember with Dan and the ICJ were part of the team that worked with you guys to make, to just input on the rules. So I wanted to find out if you were happy with the final product after you made your submissions. But thank you because you have already answered that. Thank you.
Thank you so much, sir, for the comprehensive presentation. I suppose in Lesotho you have your own constitution. I want to know if it does make reference on top of the other legislations you make reference to, if it does address the issue of access to justice for people living with disabilities. Thank you.
Yeah, actually, our constitution does not specifically address the issue of disability of the anti-discrimination clause, and it does not have a specific, or it does not have disability as a specific count for prohibited for discrimination. But the clause, when they are interpreting the law, they have included disability as a prohibited count as well. So I think that's where disability comes in. So our constitution, I think, is a traditional one where civil and political rights are clustered together as the fundamental human rights, and the socio-economic rights are not regarded as rights but as policies which the state will realize progressively. So it is under that state. Under that section of the social economic rights, where the rights of persons with disabilities have been stipulated, but now unfortunately it's something that will be realized subject to the availability of resources and they are not enforceable according to the constitution. Thank you.
Thank you, Advocate Kasi. This brings us to the end for the voting session. Check the time. Now it's okay, 1:17. So let's have 40 minutes for lunch and come back at 2, so that we will not be late for